Hello and welcome to yet another video where we get to talk about probate. And not probating the will, but what comes after that will has been admitted to probate. What comes after the will is admitted to probate? Yes, administration. Many people think that they just have to take the will to the court, that the court admits the will, and then they just run on and they live in fairy tale land. However, that is so far from the truth. Once the will has been admitted to probate, that's when the real work begins. I'm sorry, it didn't end at the courthouse. Now you have to take this will home and actually do what it says. And that is administration, doing what the will says. For many people, this may mean a deed for property that was willed to someone. Maybe it may mean going to the bank, opening up an account, grabbing all those accounts that your loved one have left, depositing in this trust account, paying all the creditors, and then make sure that the taxes have been filed, make sure the estate is totally sufficient enough to pay those bills before you pay the balance you distribute it to the heirs. Maybe that's the situation you have. In this time though, I want to talk about administration for a will. What does that look like? First, once the court admits the will into probate, the next thing you want to do is your oath. The oath is where you're swearing, I'm going to administer the provisions in this will according to how it's written, and I won't divert from it, and I'll do it to the best of my ability. That almost always comes with a bond, unless within the will, the executor had said, I don't want my executor to serve with a bond. So the testor said, I want my executor to serve without a bond, then you don't have a bond. Then you have the oath where you're saying, I'm swearing, I'm going to do the right thing. Next thing comes, you have to get your letters testamentary. That's your permission slip so that you can go to the bank and collect the money, so that you can go to the brokerage house and get those stocks, so that you can go to the mortgage company, find out how much is left on the mortgage, all the good stuff. These letters testamentary gives you the authorization, gives you the power to collect the assets. Once you have the assets, then you have to, within 90 days, file the inventory with the court. And if you're working with an attorney, your attorney will be alongside you to help you know exactly what goes on this sheet. So you fill out the inventory, you know if you have appraisals to do, or if you waive the appraisals, then you're going to put your approximation of the value of the assets and you're going to provide the claims to the court. The next thing you do is to pay the valid claims. You pay the valid claims, and then you make sure that when you're done, if there's income earned and so forth, if there are taxes to be completed, you want to make sure that that's all completed. When all the creditors have been satisfied, the proper creditors have been satisfied, then you get to distribute the assets to the beneficiaries, and then you file your closing of the administration of the estate with the court. For a lot of people, that may sound like a quick and easy route, but for many people, there's so many documents involved in there where you can be talking about a 2-year or 3-year or more affair. So pack your patience when it comes to administration, because you're gonna need it. My name is Megan Troick, and I'm the lead estate planning and probate attorney here with the Law Office of Brian Fagan, where we treat you like family. Thank you. Hello, thank you for watching our video. And because you made it to the end of that video, we're offering you our new estate planning handbook. This is a wonderful tool and I'm sure you like it. Go ahead, download the link and let's get learning together.